Hello, lovely listeners. Welcome to another exciting episode of the BPA Community First podcast, where we have legal and social conversations with the community. In today's episode, we delve into the second part of our two-part employment series. The topic for today is disciplinary actions in the workplace, when to act and how. Joining us in this episode is Mr. Ernest Osei-Afful, who is the head of legal transactions at Ecobank Ghana PLC and a board member of the Food and Drugs Authority, where he oversees legal, HR, and corporate affairs. Ernest, or do you prefer Mr. Afful?
Ernest is okay.
Ernest.
Mr. Afful is my father.
Ernest, you are welcome once again to the BPA Community First podcast.
Thank you, Mercy.
We learned a lot in the previous episode, and I'm very certain that the audience is eager to hear what you have to share with them on this topic as well. So, without wasting much time, I'd like us to delve right into it. But before we proceed, I am Bessie Jiwa Krensil, the host for today's episode.
Thank you, Bessie. It's a pleasure being here again.
So, yes, straight into it. When we say disciplinary hearings in the workplace, what do we typically mean?
So, typically, we say that before a person is condemned of an offense or an act, he has the right to be heard. And I'm sure this is a buzzword everywhere.
Mm-hmm.
So you don't just condemn an employee, you have to give him opportunity to be heard. So in employment terms, the employer will set up a formal meeting constituted by different persons, including union members if there is, or in some cases, a rep of the employees choosing.
Mm-hmm.
And that meeting or that body will go into the complaint that has been leveled against the employee and then determine whether the employee is guilty or is not. So basically, that is disciplinary hearing.
Oh, okay. So I know that the right to fair hearing is enshrined in the Constitution of Ghana,
Yes.
but apart from this, is there any other basis for disciplinary hearings in Ghana?
Yes, so we have to distinguish here between private employment and then public employment.
Okay.
Sometimes we merge them together, but normally private employment, just like any private company or a company that is not created by statute, is typically governed by the terms of the contract of employment or collective bargaining agreement or policies of the company, or as has been agreed between the employee and then the employer. So these terms will determine discipline, what constitutes discipline, what are the offenses that will come under employee discipline and all that. And we know that the effect of the discipline is various.
Mm-hmm.
So if it is a private company, these are the instruments that will determine the basis of the hearing. In public law space, for instance, public servants, civil servants, and those kind of but if you look at the Constitution, for instance, the Local Government Act and other legislation will define how disciplinary activities should be dealt with, and who should be part of the disciplinary body and how it should be managed. And you need to adhere to strictly to the requirements of these statutes in order not to fall foul of the process.
Okay, so if I get you correctly, you are saying that to determine the basis of a disciplinary hearing, you need to distinguish a public employment from a private one.
Absolutely.
Okay. So I think you've actually answered two of my questions already. So we'll just move on to the next.
Yeah, let me just add that just to set them in material particular,
Okay.
as the lawyers would say. You need the employment contract, the policy manual, the handbooks, the code of conduct, the disciplinary policy, and then the collective bargaining agreement will determine the basis of the disciplinary committee, how you should handle the process.
Okay. Yes. So when do these hearings become necessary?
So when there's a formal complaint on discipline against an employee, when a disciplinary issue is leveled up and it is of a matter that requires disciplinary committee, disciplinary hearing, according to any of these legislation or agreements that I've earlier indicated, then you will be required to go through the disciplinary hearing.
So, where there's no formal complaint, an employee cannot be invited for a disciplinary hearing.
Not exactly, because management can itself find, for instance, if the audit committee, the audit of the company, conduct investigation and realize that a certain group of employees have been involved in, they can just trigger in liaising with the HR to go through the disciplinary process. Somebody, as a result of whistleblower allegation, might have specifically raised an issue. There may be specific allegations. So there may be various instances where disciplinary hearing may be necessary in an organization, and the employee will be right to raise the necessary processes in ensuring that the disciplinary processes or proceedings are adhered to.
Okay. So, who are usually the subjects of such disciplinary actions?
Yes, so basically, I believe by subject you mean those who are liable under the...
Exactly.
Yes, so basically the employee the employee. But let me also say that it can also go beyond the employee. So, for instance, the employee may have a claim against the company or against specific officers of the company, and all these officers may have to go through disciplinary processes to determine the veracity or otherwise of these complaints.
Okay. So, I actually wanted to ask that where, for example, an employee has a formal complaint or wants to level a complaint against the employer, what then will be the approach or the best means to have this complaint addressed?
Within the organization?
Yes, within the organization.
So if the employee has a complaint, maybe against the employer itself, or against an officer, in most cases, maybe against the HR manager or his manager for that matter, depending on the disciplinary procedure. There's a disciplinary procedure that will determine the scope of the disciplinary hearing and processes. So in some disciplinary procedures that I have seen, you lodge a complaint with the HR. Some of them you lodge the complaint with the head of legal. Sometimes they will say lodge a complaint with the compliance, and then it will be given to head of HR or head of the disciplinary committee, and then they will constitute the disciplinary processes and institute the disciplinary processes, and then ensure that the matter is heard in accordance with the procedure. So basically, know the procedure in accordance with the organization's policies or agreements.
All right. Okay, I think that's actually clear. So, do the employers have any rights and duties when it comes to disciplinary hearings?
The employers, of course, they do. So when it comes to the duties and the rights of the employers, of course, sometimes we think that when it comes to the disciplinary proceedings, it is the employer who is absolutely in charge without the employee having any role. No. In most cases, of course, fair processes or fair trial, as we are trying to replicate here, requires that you give the person a hearing. So yes, the duties of the employer will include providing access to the employee to gather information and documentation in support of his defense or her claim, as the case may be. You also have to give notice of the specific allegations you have against the employee. If you are alleging that he has stolen a pen in an organization, you have to really allege that for him to prove himself. You have to ensure that there's a fair trial, and the trial is in accordance with the laid out procedures of the organization. And then you also have to take into consideration all mitigating factors that might have led to what happened. I remember some time back, I happened to handle a certain disciplinary matter, and the organization had told the workers to go the extra mile in pleasing customers. This customer stayed at work after 7 p.m., where he was supposed to have closed at 4 p.m. He stayed more than 3 hours extra. And by staying there, he tried to execute a task on behalf of a customer and made a mistake. So the organization wanted to sanction him. And well, they wrote to me as the then lawyer for the organization. I told them that, look, if you look at all the factors and you put them together, this is an employee who has sacrificed 3 more hours of his time for the good of the organization, and he made a mistake in doing that. So that's a mitigating factor that you need to consider. Don't just throw the baby with the bathwater. And it worked, and they saved him. And I'm told he rose up to become one of the best employees in the organization. So mitigation is also very important amongst other things. On the flip side, that's the rights of the employer. In the disciplinary side, you have to take into consideration the disciplinary action you are taking. And that means that look at your rules, look at your procedures. What act will amount to what? Or will require, if employee steals a pen, what is the sanction available? And then you have the right to apply that sanction accordingly. And then you have to keep record and then ensure that the officers who are supposed to be there are represented. Disciplinary action is a peculiar act in the employment scheme, and you need to be very careful. You need to get it right, because if you miss the process or the procedure, the outcome may be invalidated. So you need to be very meticulous in applying the rules as such.
Okay, so I just want to ask, in all your years of experience, what are some other mitigating factors that you've encountered during your practice as an HR?
Yes, so I have seen that in some cases the conduct of the employee over the years also come in. Because if you have an employee who has worked faithfully, diligently for 20 years, for 30 years, and has not had any blemish, and then one act that is not killing the organization, you want to throw him away, sometimes it's very insensitive. So in some cases, you realize that the company or the employer will consider your years of experience and your track record in that regard. We also look at your contribution to the organization. You may be 1, 2, 3 years in the organization, but maybe you have brought the biggest and something happened. You look at the circumstances of the act that also occurred, whether the employee intended to do what actually happened, or there was circumstantial issues that led to that. So all these also lead to some of the mitigating factors that the employer or the disciplinary body may take into consideration.
Okay. I also want to find out during these hearings. So typically, an employee, a complaint is leveled against an employee. He or she is brought before the committee. Do you find that the employers are usually sitting on the panel, or they are not part of the panel?
Well, this is a very interesting phenomenon, because in fact, if you even look at the case law, most of the cases that have been determined in employee discipline, you realize that most of the issues they raise are the panel was unfair, and I was not given a fair hearing, and I didn't even know what I was going to answer and all that. But by its very nature, it is an employer managed process. So if you look at most disciplinary procedures, they would tell you that maybe the members should be head of legal, head of HR, head of compliance, and then the employee shall appoint 2 people from maybe either welfare, or if there's a union, the union will have unions rep, and yes. So by its nature, but you should also hope that there may be some people who may not be part of management, and as we see in jury trial, who may have similar minds with the employee to also help matters. But I think, in all fairness, employers generally will want to be fair, will not want to nail its employee and tarnish his image for nothing. So if indeed there is no such act and the evidence is clear, you should be able to establish your case fairly. Of course, if the process is not fair, if the outcome is not in sync with the process, with the procedures, or with a policy, you are always entitled to go to the Labor Commission or even sue at the court for the court to look into what the organization did. And I don't think any organization will want its members to sit down for hours and have its processes thrown away.
Yes, so you also mentioned that sometimes some employees come and they say they were not given the opportunity to prepare ahead for the whole hearing. So what structures must employers put in place to ensure that their employees or workers are actually aware of such disciplinary procedures that exist in their workplaces?
So the first thing that should be done is that there should be a written down policy, disciplinary and sanctions policy. And then that policy must define the procedure. So, for instance, the procedure is that if there's an allegation against an employee, give notice to the employee, let the employee has a day or two to respond to the queries, and then in a week or in a day or two, there will be a disciplinary committee that will be constituted by the head of HR by this, and these are the people. If it's found guilty of this, the outcome will be that. So if you are found to have stolen a pen, you are going to be suspended. If you are found guilty of slapping somebody in the organization, you are going to go home. And so that I know that if I do A, B is the outcome, and then you are taking me through the path to reach that outcome, and that is what is required.
Okay, so must an employee who has engaged in misconduct necessarily go through a disciplinary hearing? I mean, does it depend on the misconduct and how gross it was?
So you have to always look at the sanctions policy, as I've said, and what you intend to achieve as an employer. If you want to just terminate the employment of the worker and let him go, you pay him, you give him his notice, and then you pay him, or you pay him the payment in lieu of notice. That one you can just terminate the employment. But if you want to take him through the disciplinary route, then it is required, and this has been held in ex parte mobile oil, Agwoda, and some series of cases that because remember that if you are finding an employee guilty of an action that is likely to lead to dismissal, then you have to have it right.
Yes.
And you need to give him some form of hearing to establish that you are fair to him. And one judge actually said that dismissal, if you are even looking at the outcome, which is a dismissal in most of these cases, dismissal is pseudo criminal in form. So if you are going to sanction somebody to that extent, then you must have a right process and ensure that you have given him the opportunity to clear his name and not based on anybody's whims and such. So it is very, very important that you take him through that process and satisfy yourself that you got it right.
So is an employee who is dismissed at the end of a hearing entitled to any benefits?
If the employee is dismissed, generally he will not be entitled to anything. But of course, you have to go back to the contract of employment, the statute, or the policy or the conditions of service. Yes, but generally, once dismissal is held, the employee is not entitled to anything.
So are there any remedies available to an employee who is aggrieved after such hearings?
So I want to presume that this employee there have been adverse findings against the employee. He has been sanctioned and he's displeased with the sanctions. Yes, there are so many ways, and you can file a complaint or petition the National Labour Commission to investigate into the process and the outcome, whether they were in sync with the law. You can actually sue the company at the court for the court to go into it, and then if the court finds that the dismissal was wrongful, they may order for compensation to be paid in most cases, as they do. You should find adversely against the employee if you have gone through the right process and the facts support the conclusion.
Okay.
Otherwise, you need to be very careful, because I mean, you should look at it from another perspective. Which employer will employ a dismissed employee? So if the employee has been dismissed, you are actually giving him a very bad certificate of employment. You are actually not going to give him, how do we call it, reference that's clean. And so you are going to affect his employment status and all that. It's like somebody who has gone to jail and nobody wants to work with such a person. So if you need to reach that conclusion, you must act right and ensure that you understood the processes and got it really in accordance with the procedures that you have set for yourself.
So is it safe to conclude that employers should rather terminate in accordance with the law and contracts and all other relevant documents than go through the whole disciplinary hearing process and then dismiss the employee?
This question is like asking me to release one of our tricks as lawyers. Yes, because I mean, it is safer to terminate the employment. I mean, I always advise that if you are not sure, or if you can't find the evidence, or you can't establish a claim that will lead to dismissal and all those related sanctions, terminate the employment and everybody goes to sleep.
I must say, I actually agree with you, even though I'm an employee. So, yes, what would be your closing advice to both employers and employees regarding such disciplinary hearings?
Sure. So for disciplinary hearings, I think essentially the parties must actually understand the procedure, the processes, and the requirements enshrined in their policies, the conditions of service and all documents relating or governing the law. You should know what it says and then know that you are going through. For the employer, make sure the allegations are right, and make sure your findings are logically related to the allegations that you actually made, and then the hearings. You should ensure that the process is valid, the members, even the membership of the panel is rightly selected, and then proper hearing opportunities were afforded the employee, and the employee took opportunities, or maybe he decided not to take the opportunities. That's fine. You can go ahead and make your findings. For the employee, sometimes employees want to walk away and then play the ostrich. You have to ensure that even if you don't participate, once they give you the opportunity, you'll be held. They will be here to have gone through the proper processes, and their outcomes will be upheld. So make sure that you go through the processes. If you have a problem with any member of the panel, you think he will not be fair to you, raise it as an objection and ask that the person recuses himself, or just as Trump is doing now to the jury, you ask that the person be taken out so that you get a panel that you think will be fair to you. And if you have anything, let it be done. Make sure everything is recorded. The records must be available and accessible to everybody. And then once that is done, the findings, if you dispute it, the record will speak to it, whether indeed they were fair, they were logical, and the conclusions, were valid. And once that is done, bingo, you are good to go.
Bingo, you are good to go. Okay, so Ernest, this has been such an insightful episode. I myself have learned so much, and I'm sure the audience has as well. I think this is a call to all employers to make sure that they have very clear policies and procedures laid out for disciplinary hearings. And our employees, I mean, myself included, make sure we read all the documents relating to our employment, from our contracts to policy handbooks to every other document that has anything to do with your employment. Make sure you read it and know what it says about disciplinary hearings. So I think it's been a pleasure being your host for this episode. Until the next time, it's been the BPA Community First podcast, where we have legal and social conversations with the community. Thank you.
Thank you.